Chief Justice Raymond Zondo says non-judges are being considered for appointments at the Constitutional Court. His comments come as the JSC has been struggling to find candidates to fill vacancies. It will not be the first time that non-judges are appointed. In 1995, Sir Sydney Kentridge was one of the non-judges to act in the Constitutional Court. And since the Chief Justice's assertions, 3 names have since surfaced and are touted to be considered for those roles. We speak to Advocate Dali, Mpofu, spokesperson for the Pan-African Bar Association of South Africa. Thank you very much, sir, for your time this afternoon and your patience with us. What is the view of the Pan-African Bar Association on the 3 names that have been touted?
Thank you very much. Well, we issued a statement in which we made it very clear that we have nothing against the 3 colleagues who have been nominated or appointed by the president. But we do have some concerns about the fact that the people who are doing the nominations or the appointments saw it fit to appoint in this day and age 3 white males for such important positions. And we think that this sends a wrong message without detracting from the suitability or otherwise of the colleagues. I personally know 2 of them. I don't know the 3rd person, the professor, but we've also heard that he has good credentials. So we have no problems with that at all. But, the Constitution makes it very clear what the imperatives are that should be considered when an appointment is made. And we find it very disturbing that a combination, actually the Constitution prescribes that 3 persons should be involved in such acting appointments, namely the President, the Minister of Justice, and the Chief Justice, who must concur. And we note in our statement that those 3 persons are themselves 3 male persons, and yet they saw it fit to appoint 3 white males to these positions, as if there is an absence of suitable black candidates, and more particularly black female candidates, who are senior advocates or senior academics, and who would have fitted the bill just as well as the other able colleagues.
To your knowledge, sir, have they already been appointed, or are they yet to just finish final touches and for you it's a foregone conclusion?
No, it's a foregone conclusion. Once the president signs, it means the process that I've just described has been completed as far as the 3 persons are concerned. So the president has now signed on the 2 names, hence the announcement was made.
Okay.
It's very regrettable, and we think that it sends so many bad messages about the appointing people themselves. If they could not find or even consult, there are so many. If we had time, I would give you 10 or 20 names of colleagues who have worked in the Constitutional Court, who have shaped the constitutional jurisprudence, who are female senior colleagues and male black colleagues as well, and for that matter, even white female colleagues who would have done this. To do this is just completely unacceptable to do this in this day and age, because anyone who is a South African knows what kind of message that sends, and it's a terrible message.
I'd like for us to focus on the message, because in your statement you note that whatever message the President, the Minister and the Chief Justice wanted to send about black legal practitioners and academics, they have missed an opportunity to vanquish the old stereotypes against black professionals and academics. What are some of those stereotypes that are still persistent in 2023?
Well, the stereotypes would have been that, black people in general and women are not capable of being constitutional lawyers or being in the top court of our country. This is a stereotype that everyone has been fighting against, which has also been proved to be nonsensical in practice, because many of our colleagues of those descriptions have excelled on the bench and in academia, for that matter. And as I say, that if we're talking about the Chief Justice in particular, he knows these people appear in his court. They've appeared in his courts even when he was still in the Labour Court for the past 20, 30 years. So he knows that the pool is very wide. And the Minister of Justice used to be a practicing attorney. He also knows the same thing. I don't know about the President, but surely the people who were assisting him should have pointed him in the right direction. We would have expected one of them, either the President, the Minister, or the Chief Justice, to have had the necessary sensitivity to understand that to send a racist stereotype about unavailable, well, it's not unavailability, it must be about lack of ability on the part of black practitioners, is setting us back 50 years, and we really are appalled by the fact that they saw it fit to do this. If there were three positions, if there was one position, maybe it would have been understandable, or two, even two. But three positions, out of three, you cannot find a single black practitioner in South Africa, then that certainly is saying something about the people themselves, about their own complexes and inferiority complexes that are dangerous for a country such as ours.
Very finally for us, you mentioned that the suitability of your colleagues is not in question. What should then we understand? Your only concern is representation. What should we understand about the composition of the Constitutional Court where representation is concerned? Is there need for reform on that side?
Oh, yes. We think that the Constitutional Court should reflect broadly South Africa, but also it should reflect the transformational objectives of South Africa. But it's not just us. The Constitution says that the President may appoint a woman or a man, and I think the constitutional writers deliberately started with the word woman. To be acting judge of the Constitutional Court if there's a vacancy or if the judge is absent. The appointment must be made on the recommendation of the cabinet member responsible, that's the Minister of Justice, with the concurrence of the Chief Justice. But the Constitution also says that the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are appointed. So we're not asking for anything special. We're asking for what the Constitution prescribes must be considered. It says the need for gender and racial diversity must be considered. It's not an option. It's not a favor that we're asking from the Chief Justice or the President. It's a constitutional imperative, and they've failed dismally to follow that constitutional imperative. And it should be any right-thinking South African should abhor such conduct, and it should never be repeated. And once again, we say that the colleagues themselves are suitable. And as we know, transformation does not suggest that white people are not suitable. It simply means that you need to affirm black people, you need to affirm black women, and you need to affirm across those previous stereotypes.
Thank you very much, sir, for your time this afternoon. Advocate Dali Mpofu speaks for the Pan-African Bar Association of South Africa.